A recent decision by the D.C. Court of Appeals may have an interesting impact on the prosecution of those charged with the Capitol breach on January 6, 2021. The case of United States v. Fischer consolidates three decisions in lower courts regarding the charge of obstruction of an official proceeding, Title 18 U.S. Code Section 1512C. Now, since many of those charged regarding the January 6 incident were charged under this statute, the decision could have wide-ranging impact. All comes down to the question of, did these people act corruptly? So we'll discuss that next, right here on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach rising generation to be free, and I'm glad you could join me today. Again, I found this case interesting, and I want to get into the details, but I also want to remind you that you can find out a lot more about what we're doing here at the website, constitutionstudy.com. You can find all sorts of details, ask questions, maybe even sign up for the Patriots update newsletter. There's a lot there, and I'll talk a bit more at the end of the episode. So please stick with me as we discuss this case of United States v. Fischer. How often have I said that words matter, or that the details matter? In the case of United States v. Fischer, Joseph Fischer, along with Edward Lang and Garrett Miller, who had their cases consolidated with Mr. Fischer's, were charged with multiple crimes from their actions at the U.S. Capitol on January 6, 2021. The question raised in this case is whether individuals who allegedly assaulted law enforcement officers while participating in the Capitol riot can be charged with corruptly obstructing, influencing, or impeding an official proceeding in violation of 18 U.S.C. 1512C2. It's that word corruptly that I want to get to, but let's back up just a little bit. Mr. Fischer, known as the appellee, moved in district court to dismiss the 1516C2 count against him because it did not prohibit his conduct on January 6th. Section 1516C reads, "Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so." The district court agreed with Mr. Fischer, but for what appears to be a very odd reason. The district court granted each appellee's motion to dismiss. After carefully reviewing the text and structure of the statute, the district court concluded that Section 1512C is ambiguous with respect to how subsections C2 relates to subsection C1. Relying on its understanding of the Supreme Court's holding in Begay versus United States, as well as canons of statutory construction, statutory and legislative history, and the principles of restraint and lenity, the district court determined that subsection C2, quote, must be interpreted as limited by subsection C1. That led the district court to hold that subsection C2, quote, requires that the defendant have taken some action with respect to a document, record, or other object in order to corruptly obstruct, impede, or influence an official proceeding. So the district court seemed to think that subsection C2 had to be related to subsection C1. And since Mr. Fischer did not interfere with any documents, records, or other objects, he did not violate section 1512C2. I find this really weird since the meaning of otherwise is in a different way or manner. Now, let's look at how the Court of Appeals looked at this case. The government asserts that the words corruptly obstructs, influences, or impedes any official proceeding in 18 U.S.C. section 1512C2 have a broad meaning that encompasses all forms of obstructive conduct, including appellees' allegedly violent efforts to stop Congress from certifying the results of the 2020 presidential election. Thus, the government contends the district court erred when it adopted an unduly narrow interpretation of section 1512C2 that limits the statute's application to obstructive conduct with respects to a document, record, or other object. So the government claims that the words corruptly obstructs, influences, and impedes any official proceedings have a very broad meaning that could include all sorts of obstructive actions, including allegedly violent acts to stop Congress from certifying the results of the 2020 presidential election. I have to point out something that, while not directly related to this case, is something every American ought to know. Congress does not certify the presidential election. They observe the counting of the votes. From the 12th Amendment, the President of the Senate shall, in the presence of the Senate and the House of Representatives, open all certificates, and the vote shall then be counted. Now, there's not a single mention of Congress voting or otherwise putting their blessing on the election for president. That aside, the court looked at the language of 1512C and came to what I think is a quite reasonable conclusion. In our view, the meaning of the statute is unambiguous. Subsection C1 contains a specific prohibition against corruptly tampering with a record, document, or other object to impair or prevent its use in an official proceeding, while subsection C2 prescribes corrupt conduct that otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. Under the most natural reading of the statute, section 1512C2 applies to all forms of corrupt obstruction of an official proceeding other than the conduct that is already covered by section 1512C1. At this point, you may think that the court is going to side with the government, and you'd be right. However, there's a single word in section 1512C which the Court of Appeals mentions that the district court did not. The word corruptly. Although the text of section 1512C2 plainly extends to a wide range of conduct, the statute contains some important limitations. The act of obstructing, influencing, and impeding described in subsection C2 must be accompanied by corrupt intent, and the behavior must target an official proceeding. Those other elements of section 1512C2 offense are not the focus of this appeal, but we nevertheless note that they provide significant guardrails for prosecutions brought under the statute. So the Court of Appeals notes the proper application of section 1512C, even though it's not a question the court is considering. I think most of us can agree that the counting of the votes in the presidential election is an official proceeding. The question is, did Mr. Fischer act with corrupt intent to obstruct that counting? Now, from the Free Legal Dictionary, we will find the word contempt means marked by immorality and perversion, depraved, venal or dishonest as in a corrupt mayor, or containing errors or alterations, especially ones that prevent proper understanding or use. For example, a corrupt translation, a corrupt computer file. Were the actions Mr. Fischer was alleged to have committed done with corrupt intent? According to the charges against Mr. Fischer, the actions he took on January 6 do appear to be obstructive. Fischer allegedly belonged to the mob that forced Congress to stop its certification process. On January 6, 2021, he encouraged rioters to charge and hold the line, had a physical encounter with at least one law enforcement officer, and participated in pushing the police. Now, it should be noted that a footnote in that quote argues that Fischer could not have obstructed the counting of the votes since Mr. Fischer claims to have arrived after Congress had recessed. However, the actions Mr. Fischer allegedly took before January 6 certainly do seem to point to a corrupt intent. Before January 6th, he allegedly sent text messages to acquaintances stating, "If Trump don't get in, we better get to war. Take Democratic Congress to the gallows. Can't vote if they can't breathe, LOL. And I might need you to post my bail. It might get violent. They should storm the Capitol and drag all the Democrats into the streets and have a mob trial." Now, based on the evidence and discussion included in the opinion and the concurrence, the court decided 2-1 to find that the district court was wrong to dismiss the obstruction charge. For all the foregoing reasons, we conclude that the district court erred in dismissing the counts charging the appellee with obstruction of an official proceeding under 18 U.S.C. 1512C2. Appellee's alleged conduct falls comfortably within the plain meaning of corruptly obstructing, influencing, or impeding an official proceeding or attempting to do so. The alternative interpretation of 1512C2 proffered by the district court and appellees failed to convince us to depart from the natural reading of the statute's unambiguous text. Accordingly, we reverse the orders of the district court and remand for further proceedings consistent with this opinion. Now, if that is true, why do I say this case could have a wide-ranging impact for many accused of obstruction on January 6th? For the simple reason that while Mr. Fischer's words and actions do show that he violated 1512C2, I do not believe that everyone who has been caught in the FBI's dragnet of January 6 rioters acted with corrupt intent. I have long pointed out that at least 5 states appointed presidential electors in a manner other than the one determined by their state legislatures, in direct violation of Article 2, Section 1, Clause 2 of the Constitution, which reads, "Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress." Furthermore, there was sufficient evidence by January 6, 2021, that problems with the elections in several states, including credible allegations of illegal activity in the collection and counting of ballots, meant that some of the electors may have been appointed by their state fraudulently. If the people who demonstrated on the Capitol on January 6 did so to protest the illegal appointment of electors, especially due to the illegal actions taken by members of the executive and judicial branches in several states, then their acts were not with corrupt intent. Rather, their actions were attempts to bring to light the corrupt intent of those who were violating the Constitution of the United States and the constitutions and laws of the several states. Petitioning your representative in government for a redress of such a grievance is not immoral, perverse, dishonest, or otherwise considered corrupt, but an attempt to restore justice to the process of choosing a president of the United States. While I cannot condone the obstructive acts committed by Mr. Fischer and others inside the Capitol that day, there's plenty of evidence that their entry was sanctioned by the Capitol Police, that most of them were not violent or disruptive, and that they did not get near enough to the House chambers to be considered obstructive. I can only hope that some of the legal teams for those who have been victims of this apparent overzealous prosecution by the city of Washington, D.C., in cooperation with the U.S. Department of Justice, will find this opinion and use it to the benefit of those peaceful protesters being illegally held as political prisoners in our nation's capital. Do you see what I mean by words mattering? Here, a simple word, corruptly, can change the entire look of how an individual charged with obstruction of an official proceeding is viewed. Were they doing so corruptly? Were they trying to destroy the process? Or were they merely trying to make sure the law and the Constitution were actually followed? That's a big difference. Who was corrupting the process? Was it the demonstrators or the executive officers and the judges in at least 5 states that illegally changed the manner of appointing electors? It seems to me it's the latter that was acting corruptly. Maybe they should be charged. Now, based on what Mr. Fischer was charging, based on the evidence provided, he doesn't get off. He did corruptly attempt to obstruct an official proceeding. But by looking at the court's opinion, we see there may be dozens, maybe hundreds of other political prisoners that have now a leg to stand on, as it's been brought to light, that word corruptly. I just hope their legal teams use it. Now, I hope this is the type of information you like finding out. If so, please go to the website, constitutionstudy.com. Sign up for one of my mailing lists, my monthly newsletter, my weekly insider. Maybe you want to sign up to get my articles and videos delivered to you by email as soon as they're published. Maybe you want to sign up to be notified about the Constitution Study Patriots program that I'm building. There's not a lot of news right now, but I'm working on it. But what's really interesting is I'm working on this mini boot camp. It's going to happen in Middle Tennessee. I'm trying to get it to happen in Bedford County, Tennessee. And I'm trying to do it around Independence Day. But I'm not getting a lot of people letting me know they're interested, that they'd be willing to show up. So if you can be in Middle Tennessee, somewhere around Independence Day, and you can make it here, you'll commit to actually trying to be here, well, then go to constitutionstudy.com/bootcamp. Let me know. Give me your name, your email address, and how many people you're going to bring with you. It'll tell me how big a venue I need and how many people are going to show up. Right now, I've only got a handful of people that have said they're going to be here. I need more if this is really going to happen. And that's important because this live event, I'm going to record. And that recording will become what the rest of the country sees. So this is your opportunity to not only see it live, but be part of the beginning of this process for the boot camp. And the boot camp is necessary because people have to go through the boot camp before they can become part of the Patriots program. So again, if you think you can make it, if you're trying to make it, constitutionstudy.com/bootcamp. Let me know, and I will find a venue, and I'll also update you as I find venues and we confirm dates and any other logistics that are going along. Now, hopefully, these are the types of things you want to find out. This is information you're looking for. And I hope you'll find it useful, and I hope that you will share it, which is really important. See, a lot of people are not getting access to a lot of good information because, well, corporate media doesn't want them to. We have to get around that. It's part of what the Patriots are going to do, and we're going to start by spreading this information. So please take the videos, the articles, whatever you find, and share it. And by the way, if you can help financially, we've had a couple of financial setbacks here at the Constitution Study. I had some equipment go bad and I had to replace it, and it cost a few $1,000s. If you can help, well, you can donate at the website. That'd be great, whether it's a one-time donation or a monthly donation. All that money goes to keeping the Constitution Study up and running. It does take a lot of money, and I need a little bit of help. But if all you can do is share the news, share these articles, the videos, post my stuff on social media, I would appreciate that greatly. And hey, hopefully you'll come back next time. Maybe bring a few friends to the Constitution Study.
Love the neighbors and have a few good friends.